5 years after the alleged incident.
Same.
Same thing.
Facts are a bit different. Kindly
I'll
permit
hear you.
permit me to address.
Yes, sir. ಅಲ್ಲ ನಿಮ್ದು ಅಷ್ಟೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನಿಲ್ವಾ?
Yes, just two things I just wanted to.
And charge sheet is also filed in this case.
ಇದರಲ್ಲೂ ಆಗಿದೆ, ಎಲ್ಲದರಲ್ಲೂ ಆಗಿದೆ ಚಾರ್ಜ್.
Charge sheet is filed.
In the
ಒಂದರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ 66 ಇದೆ.
ಒಂದರಲ್ಲಿ ಆಗಿಲ್ಲ.
ಹಾ, ಒಂದರಲ್ಲ.
ಇದರಲ್ಲಿ ಈಗ ಜಸ್ಟ್ ನಾವು ಚಾರ್ಜ್ ಶೀಟ್.
ಎಸ್ ಸರ್, ಯು ಮೇ ಸಬ್ಮಿಟ್ ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ಇದು ಬೇಲಾ?
Bail. 438.
Anticipatory bail.
ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್. ಆಲ್ ರೈಟ್.
4th.
ಎಸ್ ಸರ್.
Only one feature in this I have to just, with all responsibility, I have to say this, not a little bit slightly difficult. After the alleged incident, she says prior to lockdown, she says she continues to stay there. That incident was repeated twice. These are unusual.
That is why 376(2)(n).
It's ಸ್ವಲ್ಪ unusual. It looks. That's all. I will leave it at that. But
But all the other submissions are same.
same 5 years, everything made sir.
ಎಲ್ಲ 5 years.
Yes.
Same complainant?
ಇಲ್ಲ ಇವ್ರು ಬೇರೆ ಅವ್ರು.
Some different complainant.
She says she met the original complainant, the person first matter I argued. And when this matter when video started circulating, then her husband asked her why. Then she says, no, I thought it is fit enough now. And earlier my daughters were not grown up. Now my daughters are grown up and married. Therefore, I have taken the courage. Several matters, not subject matter of trial, according to me. There are contentious issues, including FSL
Of
report.
course, for caution and ಕೇಳಿಲ್ಲ.
No, I'm not. I'm only bringing to lordship's note.
Yes, sir.
Babe, I request the court to kindly permit me to show the nature and gravity of the offense that has been alleged against the petitioner.
Page, sir.
Page 18. Starts at page 19. It's a very disturbing this thing. I'll be grateful if the court can go through it.
Yes, I'll go through it. Paragraphs ಹೇಳ್ಬಿಡಿ. ನಾನು
19, 20,
2021 lockdown and ಶುರು ಆಗುತ್ತಲ್ಲ.
21. And more importantly, she has fully explained the delay. Kindly come to page 21. Before that, why did she not complain immediately after the first incident? Page 19 may kindly be perused. Bottom of that paragraph. ಬಲವಂತ ಹಾಕುತ್ತಾ ಇನ್ನೊಂದು ಕೈಯಲ್ಲಿ ಮೊಬೈಲ್ ಹಿಡಿದುಕೊಂಡು ಬೇಡ.
ನೋಡಿದೆ.
ಆಮೇಲೆ ಇದು ದಿಸ್ ಇಸ್ ಹೌ ಶಿ ಎಕ್ಸ್ಪ್ಲೈನ್ಸ್. ಆಮೇಲೆ
ಪೇಜ್ 20 ಅಲ್ಲ,
19ರಲ್ಲಿ
ಆಮೇಲೆ ನಾನು ಯಾರಿಗಾದರೂ
ನೀನು ಯಾರಿಗಾದ್ರೂ ಹೇಳಿದ್ರೆ ವಿಡಿಯೋ ನಿನ್ನ ಮಗನಿಗೆ ಕಳಿಸ್ತೇನೆ ಅಂತ ಹೆದರಿಸಿ. 20ರಲ್ಲಿ ಡಿಲೇ, ವೈ ಡಿಲೇ ಅನ್ನೋದಕ್ಕೆ ಶಿ ಹಸ್ ಎಕ್ಸ್ಪ್ಲೈನ್. 20ರಲ್ಲಿ ಸೇಮ್ ಅಗೈನ್ ಎಂಡ್ ಆಫ್ ದಿ ಪ್ಯಾರಾಗ್ರಾಫ್. ಕೈಲಿ ಮೊಬೈಲ್ ಹಿಡ್ಕೊಂಡು ನನ್ನ ಸೋಣ್ಸೋ ಆಮೇಲೆ ಕೂಡ ಯಾರಿಗಾದರೂ ನಡೆದಿರುವುದನ್ನು ಹೇಳಿದರೆ ನಿನಗೆ ಒಂದು ಗತಿ ಕಾಣಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. So she has said why she did not immediately complain. But after this incident, one more incident happened. In the next paragraph, she has said, and same day she left the house. Now kindly come to page 21. Bottom of that paragraph again. ನನ್ನ ಕುಟುಂಬದ ಸದಸ್ಯರು ಈ ರೀತಿ ಹೇಳ್ತಾರೆ, ನೀನೇನು ಯೋಚನೆ ಮಾಡಬೇಡ, ನಾವೆಲ್ಲ ನಿನ್ನ ಜೊತೆಯಲ್ಲಿ ಇದ್ದೀವಿ ಎಂದು ನನಗೆ ಧೈರ್ಯ ತುಂಬಿದ್ದರಿಂದ, ನನ್ನನ್ನು ಕೌನ್ಸಿಲಿಂಗ್ ಮಾಡಿದ ಆಪ್ತ ಸಮಾಲೋಚಕರು ಕೂಡ ಹೆದರಬೇಡಿ, ನಡೆದ ವಿಷಯದ ಬಗ್ಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡಿ ಎಂದು ತಿಳುವಳಿಕೆ ನೀಡಿದ್ದರಿಂದ ಯಾವುದೇ ಒತ್ತಡ ಮತ್ತು ಭಯವಿಲ್ಲದೆ ಸೋನ್ಸೋ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ, ಘಟನೆ ನಡೆದಿದ್ದಾಗ ನನ್ನ ಕಿರಿಮಗಳ ಮದುವೆಯಾಗದೇ ಇದ್ದಿದ್ದರಿಂದ ಮತ್ತು ನನ್ನ ಹಿರಿಯ ಮಗಳ ಜೀವನದ ಮೇಲೆ ತೊಂದರೆಯಾಗುತ್ತೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ನೀಡಲಿಲ್ಲ. ಈಗ ನನ್ನ ಮಕ್ಕಳು ಮತ್ತು ಅಳಿಯಂದಿರು ವಿಷಯವನ್ನೆಲ್ಲ ತಿಳಿದುಕೊಂಡು ನನ್ನ ಜೊತೆ ನಿಂತಿರುವುದು ಲೇಟ್ ಆಗಿ ಕಂಪ್ಲೇಂಟ್.
She was also a maid.
She was domestic servant working in the house, in the estate,
The estate, huh?
in the estate. And she was taken to Bangalore. Again, the same thing happened in Bangalore house also. Now with the,
Sorry.
Yes, yes.
that's why N is invoked. It was a
That's what.
serial this.
ಅಲ್ಲ ಅದಕ್ಕೆ 376(2)(n repeated rape.
Kindly recollect the facts. I will not repeat it. Now,
But then this is too gory. What is narrated?
if there is something which can fit into a nymphomaniac's description, it outsmarts that also. It outsmarts that. Sir, the more aggravating factor is the lady was not only under her control and his control, and he was dominating. She was double the age of the perpetrator, petitioner, if not more. And such a lady, she held his feet. I don't want to.
Yes.
Then
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಲ್ಲ ಇದರಲ್ಲಿ ಈಗ?
charge sheet ಆಗಿದೆ.
ಎಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್?
ಕೊಡ್ತೇನೆ. ಒಂದು ನಿಮಿಷದಲ್ಲಿ ಕೊಡ್ತೇನೆ.
ಹಾ.
I would also request the court to kindly recollect. It is this lady who was abducted. Once just before election, then immediately after election. Kindly come to page 27. Page 27 of the petition.
Yes, that's the order.
Yeah, the order portion, but I'll straight away take the court to page 95.
90?
Now, this is a suit filed by him, OS 3394 of 2023.
Asking restraint.
Yes, this was filed 1 year before the complaint was lodged.
Why
On
was it
1/6.
filed 1 year before the complaint?
He knew everything. He had recorded everything. He knew everything that is being circulated. So 1/6/2023, he files a suit, gets an injunction, and silences the media houses against publishing the material that he had recorded in his phone. And more importantly, after securing the interim order, I request the court to kindly note this. No criminal case has been filed. The stand here also, the photographs are morphed, the videograph is morphed, the victims are shown this thing. So, if that is so, there should have been a criminal case saying that this has been morphed, this results in such and such an offense. No such criminal case was filed. Then victim is not a party to this suit. And more importantly,
Victim is not a party.
not a party. And no criminal case is filed against the victim, even at that point of time. So that is how he has secured an interim order, ex parte interim order, and
Which interim order?
there in the suit,
Suit.
in the suit. Now, the very important factor is, I've given the list of authorities. Kindly permit me to refresh just 2 of them.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಈಗ ಕೊಡ್ತಾ ಇದ್ದೆ.
ಹಾ.
ಅಲ್ಲಿ ಹಿಂದಿನ ಕೇಸುಗಳಲ್ಲೂ ಕೊಟ್ಟಿದ್ದೇನೆ.
ಹಾ.
In the first case, that is Prashant Kumar Sarkar versus Ashish Chatterjee and others. Can you come to para 9, here, page 4.
Yes, ಇದನ್ನ ಹೇಳಿದ್ರಿ ಅವತ್ತು.
ಹೌದು.
Yes.
Sir, all the 8 factors
Yes.
are answered positively. He is a flight risk because he had gone away, escaping the process of law.
34 days he was out.
Yeah, he was out of country. And then severity of the nature and gravity of the accusation, it is so serious and it is a heinous crime. Danger of the accused severity of the punishment in the event of conviction. That is also there, positive. Danger of the accused absconding or fleeing is also answered affirmatively. Character, behavior, means, position, standing of the accused, all of them are to be taken into consideration. The most powerful community family in the district, and politically powerful, financially also very rich, and they have been employing it in a big way in silencing the victims. Sixth one, likelihood of the offense being repeated. This is 376N. It is a
Repeated.
continuing cause of action for denying bail.
Yes.
Reasonable apprehension of the witnesses being
Yes.
influenced.
According to you, all the 8 are present.
All the 8, sir, they had already abducted the victim. What more is necessary to say that such a man is not entitled to? Then I thought I should show some of the weighty observations of the Honorable Supreme Court in the case of Jugendra Singh, which I have produced at page 10, page 8. Sorry, it starts at 6, page 6. Now kindly come to paragraph. Is the paragraph?
49.
Yes.
Rape or an attempt of rape.
Yes. Rape or an attempt to rape is a crime not against an individual, but a crime which destroys the basic equilibrium of the social atmosphere. The consequential death is more horrendous. It is to be kept in mind that an offense against the body of a woman lowers her dignity, mars her reputation. It is said, one's physical frame is his or her temple. No one has any right of encroachment. An attempt for the momentary pleasure of the accused has caused the death of that was a child rape, and had a devastating effect on her family, and in the ultimate event on the collective at large. When a family suffers in such manner, the society as a whole is compelled to suffer, as it creates an incurable dent in the fabric of the social milieu. In the next judgment, sir, page 3, that is at page 21, Shyam Narayan versus State, the opening paragraph itself.
Wanton lust, I've seen.
Yes.
this. Deepak Mishra.
And
Depravity of senses.
last
yes.
time I did not point out these paragraphs. I
No,
request
this,
the court.
this I have seen.
ಅಲ್ಲ ಇದನ್ ತೋರಿಸಿದೀನಿ. Para 1 ತೋರಿಸ್ದೆ,
Ah,
but subsequent paragraphs I forgot to show. Kindly come to para 19. Kindly permit me to read
yes, sir.
para 19. The aforesaid authorities deal with sentencing in general. As seen, various concepts, namely gravity of the offense, manner of its execution, impact on the society, repercussions on the victim, and proportionality of punishment have been emphasized upon. In the case on hand, we are concerned with the justification of the life imprisonment in a case of rape committed on a 8-year-old girl. Next sentence is important, sir.
Yes.
The victim was both physically and psychologically vulnerable, as in the case of the present victim, both physically and cerebrally. Then at para 22 refers to State of Punjab versus Gurmeet Singh. At placitum C, kindly mark these words. The learned judge has proceeded further to state that it is an irony that while we are celebrating women's rights in all spheres, we show little or no concern for her honor. It is sad reflection of the attitude of indifference of the society towards violation of human dignity of the victims of sex crimes. Then that this thing is quoted. Para 23, Krishnappa's case from Karnataka, I quote,
Yes.
courts must hear the loud cry for justice by the society in cases of heinous crime, of rape on innocent, helpless girls of tender years, and respond by imposition of proper sentence. Public abhorrence of the crime needs reflection through imposition of appropriate sentence by the court. And last but not the least is para 25, which speaks of brutality, which is writ large in this case. Keeping in view aforesaid enunciation of law, obtaining factual matrix, the brutality reflected in the commission of crime, the response expected from courts by the society, and the rampant uninhibited exposure of bestial nature of pervert minds, we are required to address whether the rigorous punishment, etc., etc. That is. Then last, para 27, respect for reputation of women in the society shows the basic civility of a civilized society. No member of society can afford to conceive the idea that he can create a hollow in the honor of a woman. Such thinking is not only lamentable, but also deplorable. It would not be an exaggeration to say that the thought of sullying the physical frame of a woman is the demolition of the accepted civilized norm, that is, physical morality. In such a sphere, impetuosity has no room.
Those are
The youth-
appeals against conviction.
Allah, even for
Observation.
granting bail also.
In fact, Bhagwan Singh.
Yes, Bhagwan
Bhagwan
Singh.
Singh is the one that is to be looked into.
Please, please.
If you see para 18, 24 and 25.
25,
Bhagwan Singh.
next. Page 40.
18 of course that is there.
Page 40.
Yes.
That also I placed.
ಇದು ಅದರಲ್ಲೂ rely ಆದ್ರಿ ತಾವು.
Ah.
24 and 25.
Yes, 24 and 25. Then Pool Singh's case also I placed.
Pol Singh also, yes.
Page 51. So these were pointed out.
Delay would not completely take.
Not at all, not at all. And more importantly, the sole testimony of this victim is sufficient to convict a person who accused of it. In this case, there are two more factors which need to be impressed. One is, just before the election, on 23/4/2024, a crime was registered in crime number 33 of 2024 under section 67A of the Information Technology Act. There also, because my face is shown, according to
Your
him,
face is shown.
yes, I'll give those details as well. My face is shown and no steps are taken against me. If it is marked, I should have been the instrumental factor to bring about morphing of this thing. No such complaint, no such criminal case has been presented. So it is in these circumstances, I request the court to kindly permit me to show from the charge sheet. Apikotra. Yeah.
This is crime number 2 of 24.
Yes, 20th. Now kindly come to.
We
Volume
don't have-
1.
I must bring to lordship's notice. But I have no objection for the prosecution placing reliance upon the contents of the
Court of-
charge sheet. But we
Yes.
don't have the benefit of the copy of the charge sheet.
It's all
No, I must bring to lordship's notice, but that would cause some prejudice to us. But because, no, if not, we would, in the other, for the
Page
other matter, we had the.
I have
copy of
given
the
the
charge-
synopsis of the charge sheet, page 111.
If they are to provide a copy of that note, whatever
Sorry,
they are
sorry,
relying
see,
upon.
Not
but
entitled, not
Oh,
entitled.
it's all
under
right.
the, I have seen the provision.
Whether I rely on this or not, we will pass an order. Yes.
No, only there is a
I will
very
look into
strong corroborating factor,
No, this
which I should bring.
That's a matter of trial.
Alla,
We are on anticipatory.
Not
bail.
sir, in the other
Anticipatory
matter,
bail
when charge sheet
ಕೊಡೋದು.
was filed.
How strong
I was
the
a-
case is ಅಂತ ತೋರ್ಸೋದಕ್ಕೆ. Kindly permit me to show one fact.
ಅದೇ ಕಂಪ್ಲೇಂಟ್ ಸಾಕು.
ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಸಾಕು, ತಾವು ಪರ್ಮಿಷನ್ ಕೊಟ್ರೆ kindly come to volume 4. I will not read it. I'll just show it to the court. This is the detailed FSL report that has been received.
Page.
Page 1613 starts at page volume 4.
1613.
Volume 4.
Volume 4.
1613.
ಇದು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರಿ, ಮಾರ್ಕ್ ಮಾಡಿದ್ವಿ.
ಅದು ಇನ್ನೊಂದು ಕೇಸ್.
ಆ ಕೇಸಿಗೆ
ಹಾ.
FSL
ಇದೊಂಥರ ಆಕ್ಷನ್
ರೀಪ್ಲೇ ಅಲ್ಲ ಇದು
but worse than that in this case for the first time, he has been caught on the video. He was not so well guarded as he was in the other cases.
No, this,
So his voice is recorded.
that is what I asked on the last occasion.
Yes.
Voice is recorded.
Voice is
No,
recorded.
last, that, no, voice, they said it is mismatched. Not, I do not know about this at
No,
all. But this is a different
the
case.
facial features of so and so present in the video are similar to respect of facial features
Then ನಮಗೆ
so and so. And voice is,
this is a different case. That's what I say.
charge sheet same alva?
ಇಲ್ಲ, ಇಲ್ಲ, ಇಲ್ಲ.
Oh, it's better.
ಇದು ಹೊಸ case.
Separate case,
ಅದು-
you don't have the benefit of what.
Sir, kindly come to 1617.
1617.
17. Same FSL report.
Voice feature extraction. Ada?
Extracts. Kindly go through the cry of the lady. Then page 1618. Based on the frame analysis, the video files mentioned above from 1 to 3 are found to be continuous, not edited or morphed. So they are found to be genuine.
161?
1618,
Ah,
after the tabular statement,
ah,
based on frame analysis,
are found continuous, not edited
Kind-
or morphed.
yeah, kindly go through that short paragraph, the whole of it,
Yes.
that they are shown to be genuine, they are shown to be not edited, they are shown to be not morphed. Then the identity of the victim after the next tabular statement. The facial features of the female individual present in above mentioned video file are similar with respect to facial features of the female individual present in alleged video files of Samsung mobile phone marked D1A. The system generated facial feature comparison reports are enclosed. That is again this thing. Now kindly come to 1619, para 7. Para 7 is important,
Yes.
where the speech of the accused is fully recorded and is found to be similar with the voice samples taken. The comparison of the respective voices of auditor, etc., of the male speaker accused, Sri so and so, recorded in alleged video, etc., present in Samsung mobile, and the sample speeches found recorded in the audio files of ScanDisk, micro SD are similar. Next, again, the cry of the lady, that there is a transcript.
Yes, yes.
Para 10 again, para 11 again. So after this, the FSL refers to the text of the video. Kindly come to page 1623. ಸರ್ ಅದು ಓದ್ಲಿಕ್ಕೂ ಕೂಡ ಬಹಳ ಡಿಸ್ಟರ್ಬ್ ಆಗುತ್ತೆ.
ಎಲ್ಲಿದೆ?
1623.
Oh, this, yes, yes.
ಹಾ,
No, no, please don't read.
ಇಲ್ಲ ಓದಲ್ಲ. ಇದೆಲ್ಲ ಕೂಡ because the defense taken in the court below was, it was a consensual act. That was the defense. Now her protest, her rejection, her shout, her cry, her agony, everything is recorded on video. (307) page, volume 1. The entire transcript of all the details, how he forced the victim to subjugation are brought up. That is 309.
307.
ಬೇರೆ?
307 also
ಅಷ್ಟೇನಾ?
is, I submit.
Heard reserved.
Before I close, I should narrate. It has nothing to do with this
No, no.
case, my learned friend.
No, no, that's.
Alla,
Again, cases
not
are-
with this case.
No, one clarification. Why did you institute a suit seeking restraint in
Reason was also-
2023?
The reason was certain videos were being circulated,
What videos?
but saying that there was an sexual act in which the petitioner was involved. But of course, my names were not there. But kindly see para 3 of that watermelon by this Karthik this driver, page 89. Page 89, paragraph 3.
So videos were circulated.
So photographs, and
Page?
page 89, paragraph 3.
Yes. Defendant 88, that
They
is,
sent a fake and mock
Karthik.
photograph to plaintiff through WhatsApp from mobile number so and so to WhatsApp photos of some unidentified.
photograph of plaintiff.
Yes, sir.
With some random women.
Yes.
So videos were there.
The defendant number 88 threatened the
Videos
plaintiff
were
with creating
there.
more photographs.
Incident is not denied or disputed anyway.
Lots, I
No,
must.
It's all right. I wanted clarification.
Please.
Why did you on yourself 1 year before all
No,
this
that is
happened?
because the photograph, this person, my lord, defendant number 88 had sent the photographs. And he, my lord, says that I took the phone from the petitioner and got this. Finally, my lords, when the phones are seized, petitioner's phone is not seized. The phone from which he says these photographs or videos were taken are not available. It is his phone, which ultimately is seized, the driver's,
Karthik's.
defendant number 88's phone.
But even then, why you had to go on
This is
yourself
because
and-
these photographs or this one is not traced back to the phone of the petitioner. I instituted the suit because my lord, he called me up. He sent photographs of mine. But ultimately, my lord, in the FSL report, which I pointed out last time, the face of the petitioner is not seen at all.
There's a voice match.
Now that is what I don't have the benefit of that.
This is the
Anyway,
voice.
it's all right. I will, but these are all matters, my lords, which we can contest. We are unable
No,
to contest at
contest,
this
yes.
stage.
It's a matter of trial, no doubt
No,
about it.
therefore,
but,
of course, statement made in the complaint, there are several circumstances which could show. No, there are several circumstances which, my lord, I may point out, but I did not want to, my lord, go because at this stage it is my say as against theirs, which, my lords, has to be dealt with very delicately. But I will only put it across in this manner. Because the reason is not this. 21 prior to lockdown, she says this happened. She says I continued to stay there. Once, twice, or thrice. These are depicted.
did she have any choice?
These are the questions. These are the questions, Lords, as to whether. Therefore, Lord, I was very responsible when I made that submission before your Lordships. I do not want to travel beyond anything else to say as to whether 376 occurred or not. But merely, Lord, making those statements in the complaint at that stage, but should not, Lords, be taken that a case of 376 is made out of that. And reading out the contents of the charge sheet, actually, we don't have the benefit at all of that. Relying upon that would cause
The
serious
FSL.
cause some serious prejudice to us. That is what I want to bring to Lordship's notice. Of course, these are all matters, my lord, which requires to be.
Trial, yes. No
No,
doubt
I am
about it.
only bringing to Lordship.
So there are 3 anticipatory bail petitions
So
now.
there is a
Three anticipated.
One is
One
two
439.
one is regular bail,
Is 439.
in which that is 376.
correct,
One anticipatory bail 66C,
correct.
that is
In-
with others for
Yeah,
circulating.
there are others. Sir.
Then another anticipatory bail is 354A.
Jilla Panchayat former member.
354A. The fourth one,
This
is this anticipatory bail.
Correct. These are all.
All right.
The experience I wanted to narrate is not of.
And Lord, I just wanted
of my
to,
own-
before Leonard
Allah,
Singh,
my own-
not nothing.
Not-
the
not
judgment-
related to this case.
Allala sir,
ನಾವು
ಬೇರೆ
ಕೇಳ್-
ಏನು?
ಅಲ್ಲ, ತಾವು
ಅಲ್ಲ,
ಕೇಳ್ಕೊಳ್ಳಿ ಇದನ್ನ. ಆಮೇಲೆ
One the submission I wanted to
ಏನು
make,
ಅಂದ್ರೆ
not on this.
Justice Govind Bhatt was the Chief Justice here. There was one quota officer by name Bhimrao.
Hmm.
Justice Govind Bhatt never handled any criminal matters. It was only writ appeals or CRPs he used to handle. Then soon after he retired, Justice Honnaya and Nesargi, they shifted to Kotal 1. So Bhimrao became their court officer as well. But Honnaya would not change the roster. He would continue with his criminal appeals. And the criminal appeals were being heard in Kotal 1. After 2 days, Bhimrao was the court officer at that point of time in Kotal 1. He went and prostrated before Justice Honnaya, said, Swami, ನಾನು ಕಣ್ಣು ಮುಚ್ಚಿದ್ರೆ ಬರೀ ಕೊಡ್ಲಿ ಚೈನು ಚೂರಿನೇ ಬರ್ತಾ ಇರೋ ದಯವಿಟ್ಟು ಬೇರೆ ಕೋರ್ಟ್ಗೆ ಹಾಕಿತ್ತು. That is my fate today. I have been requesting the government.
You have been arguing some For the last 16 weeks, I'm hearing only this.
I've been telling the government, please change this thing. It has become impossible for me to go through this agony,
Because you're not in this
not regularly handling.
regularly ಇದು ಮಾಡಲ್ವಲ್ಲ ಹಾಗಾಗಿ it's very difficult.
So ಈ ಭೀಮ್ರಾವ್ ಕತೆ ನಂದಾಗ್ಬಿಡಿ. That is what I wanted.
No, I only wanted on merits mode. I wanted to say one more
Yes,
thing.
sir.
The judgment which the Learned Senior Council has relied upon. But of course, all those judgments speak of crime against women, etc. There cannot be any dispute at all. But fact situation, it depends. But in every case, some cases, POCSO was invoked. And I just post-convict,
I know.
post-convict, no, I'm just bringing
The
to Lordship's
other
knowledge.
case of Bhagwan
Yes.
Singh was spoke so. correct.
Therefore, Murad, factually, Murad, several, it is
He'll
only on factual aspects, Murad, their lordships have held that sometimes. There are, of course, some judgments which say that delay, particularly in 376 matters, cause serious,
Last time ಹೇಳಿದಿರಲ್ಲ.
I will leave it at that. So any conditions lordships are to impose, but they will comply. Mobile forensic,
Objection
but I'm
statement,
also
court
told,
of, court of
I'm also told
statement.
the FSL report, whatever they were able to gather, though we don't have the, it does not relate back to the mobile phone of the petitioner.
No, not mobile phone of the petitioner. Samsung ಯಾರ್ದು?
I'm told that there is a separate chapter dedicated to mobile forensic report.
We'll see. If necessary,
Yes.
if need arises, we'll go into.
Yes.